Mr. Luisen.
Sir, I stand in support of the sweeping changes introduced by this bill to ensure that our criminal laws and regime are well placed to tackle new crime trends and are aligned with societal norms of our times. I would like to start by commending the government's decision to provide for a longer 3-month period between the first and second reading of the bill. This allows both parliamentarians and the public to better understand and seek clarifications on such a crucial and comprehensive bill. I hope that this practice will be similarly adopted for other bills which are equally important and extensive. I would also like to commend the progressive reforms this bill introduces. Another applaudable aspect of this bill is the Penal Code Reviews Committee's extensive effort to obtain public input in this review. More than 700 stakeholders participated in the engagement sessions, and more than 60 individuals and organizations provided written feedback. The committee included leading practitioners and thought leaders from academia and the private and public sector. To further strengthen these commendable efforts at engaging the public, would the government also consider including civil society groups on future review committees for any legislation? Civil society voices could have been especially value-adding and beneficial to the review process, given that many of these groups provide direct services and have expertise in the different issues areas subjected to review. In fact, these groups may have more experience dealing with certain groups of victims that avoid the authorities or are less inclined to report crimes and can provide valuable insights on these blind spots. I hope that it will become a standard practice for civil society to be included in committees spearheading legislative review rather than just at the consultation stage. Next, the bill takes a progressive step of abolishing the offence of attempted suicide. This recognizes that suicide attempts stem from deep-seated issues, and a punitive approach may not be appropriate or sufficient in addressing them. Beyond legislative reform, we can go further in addressing the needs of those who attempt suicide by ensuring that the authorities have the skills and resources to respond appropriately when these cases arise. Police officers are deployed when an attempted suicide case is reported. Police officers are trained in responding to emergency situations, but may not have sufficient training in handling the complex social, emotional issues often associated with attempted suicide cases. There is considerable value in having trained professionals who can be at the scene to do any assessment on mental health or provide psychological interventions when necessary. Similar trials have been conducted in the United Kingdom. I have 4 recommendations to make here. First, will the Ministry look into improving the quality of response to attempted suicide by setting up a specialist team with psychological first aid training that can be deployed when attempted suicide is reported? Second, given that it may take time to train a specialist team, will the Minister consider deploying social workers together with police officers when responding to attempted suicide cases? This would help ensure that there are experts on the scene who will be able to handle all aspects of the situation better. Third, will the Ministry consider making it mandatory for frontline police officers to undergo psychological first aid training? This will ensure that the process is not as distressing for people who attempt suicide. Finally, will the Ministry look into expanding the functions under the existing My Responder app by SCDF for responding to attempted suicide cases? The My Responder app works by notifying community first responders who are members of the public trained in CPR or AED procedures of nearby fire and medical cases. The app could similarly notify trained social workers or counsellors who are available and in close proximity to the scene of attempted suicide cases so that they can assist the police with negotiation efforts. Next, the bill repeals the marital immunity for rape, something which I and many members of this House have spoken up about and which have been strongly supported by members of the public and representatives from the religious, legal and social sectors during the public consultation process. Rape is wrong in any context. Can the Minister confirm if marital immunity for rape is completely removed? Currently, Section 376A penalizes acts of sexual penetration against minors under the age of 16, but does not apply where there is spousal consent. Similarly, Section 3751 provides that penal vaginal penetration of a girl under the age of 14 is rape, but does not apply when there is spousal consent. The position is same under the new Section 3751A for oral and anal penetration. Section 376A(5) states that it is not an offence for a man to penetrate his wife if his wife is 13 years old and above. This means that it is possible for a child between 13 and 16 years old who is in a marriage to give spousal consent to sex, even though it would otherwise be considered as rape. So the age of the child should be the only factor here, and not whether she is married to the man. One other positive aspect I would like to highlight is the raising of the minimum age of criminal responsibility, or MACR, from 7 years old to 10 years of age, where the child below this threshold are considered incapable of crime. While this is a step in the right direction, would the government consider further raising this minimum age to 12 years old, in line with the Convention on the Rights of the Child? Paragraph 32 of the CRC recommends that states increase the MARC to the age of 12 years old. Some have argued that logical thinking and problem-solving skills only develop between 11 to 15 years old. Some also suggest that intellectual abilities reach adult levels at only 17 years old. Children with underdeveloped logical thinking, problem-solving and intellectual abilities are more likely to exhibit risky and potentially criminal behavior. While this change puts us on par with the laws in England and Hong Kong, so I believe that Singapore could benefit for setting a positive precedence for other countries by meeting the internationally acceptable standards or levels of 12 years old. So notwithstanding my above clarifications, I stand in support of this bill.